Today we are speaking with New York labor lawyer Abdul K. Hassan. Mr. Hassan's law firm practices labor and employment law, and he'll be answering some questions about the rights of employees to receive overtime pay. Mr. Hassan, what is overtime pay?
Overtime pay is where an employee works more than 40 hours in a week and are entitled to 1.5 times their regular rate for all the hours they work over 40. There's a very popular and famous federal law known as the Fair Labor Standards Act, or the FLSA. The FLSA, which was enacted around 1938, requires in general that employers pay their employees 1.5 times their regular rate for hours they worked in excess of 40 hours in a given week. Now, states like New York, like almost every other state in the country, also have overtime laws which track or follow the FLSA, and they also require overtime pay uh, to the employee if the employee works more than 40 hours in a given week.
Can you give me an example of how overtime pay is calculated?
Yes, let's say an employee is paid $10 an hour and the employee works 50 hours in a given week. To calculate the employee's base wages and overtime wages, we will do it as follows. We will take $10 an hour times 40 hours. That gives us $400 in base wages. And we will take 10 hours of overtime, these are the hours over 40, and multiply by $15. $15 would be 1.5 times the regular rate of $10. So we will have $150 worth of overtime wages for that week for a total weekly wage of at least $550 for the week. Now, if the employee is a salaried employee, not, in other words, not being paid by the hour, and if the employee is also entitled to overtime, we will divide the salary by the number of hours that the salary is intended to cover. When we get that hourly rate, we will then use that to calculate the overtime pay. Here, the overtime being 10 hours, then whatever that hourly rate is, we'll do 1.5 times that and multiply by the overtime hours. Also, we should note that in addition to the salary or the hourly wage, additional compensation such as commissions generally should be included in the calculation of the overtime hourly rate and hence would produce a higher amount or a greater amount of overtime wages for the employee. And this is sometimes a very common mistake that employers make and something that employees don't understand they're entitled to.
Are there exceptions to the general rule that employees working more than 40 hours a week are entitled to overtime pay?
Yes, there are certain exemptions. The most common of these exemptions is called the EAP exemptions, or the Executive, Administrative, and Professional exemptions. However, employees should be aware that the rules concerning these exemptions are very complex, and there are many rules that the employer must satisfy. Secondly, not only are the rules several and complex in nature, but the employer has the burden of proving that the employee is exempt. The employee does not have to prove that he or she is exempt from receiving overtime. And this is significant because the fact that the employer has the burden would be critical or significant in the decision whether to or not to make a claim for overtime pay against the employer.
If the employer classifies the employee as exempt, does that mean the employee is not entitled to overtime?
No, it's not. It's not up to the employer to determine whether the employee is entitled to overtime. The law dictates whether or not the employee is exempt. And as you might imagine, the employer would have a lot of incentive to misclassify an employee. Sometimes employers misclassify employees because they do not understand the exemption rules, and also some of them would misclassify the employee because they deliberately intend or try to avoid the payment of overtime. Now, there are two very common examples of misclassification. One involves workers who were misclassified as independent contractors, and they're paid with a 1099. So by misclassifying them as independent contractors, the employer doesn't pay them overtime because only employees are entitled to overtime. And an independent contractor, by definition, is not an employee. Now, if that classification is wrong, and we know the way we would know if it's wrong, we would apply a certain test that's being articulated under the FLSA as well as the IRS rules. And if the employee is not an independent contractor, that employee, if he or she worked overtime, would be able to recover overtime for whatever period they're owed. The second example of misclassification is where the employer agrees that the worker is an employee but misclassifies them as exempt. Once again, if the classification is wrong, then they have to repay whatever overtime is owed for that period of time. And these are some of the very common instances of the lawsuits filed against employers. The misclassification issue has given rise to a lot of lawsuits against employers.
Can an employer fire an employee because that employee complains about not getting overtime pay, or because the employee files a lawsuit for overtime pay?
No, the law is very strict. If an employee complains about overtime pay or files a lawsuit for overtime pay, the employer cannot use the fact that there was a complaint about overtime or a lawsuit about overtime to take any adverse action against the employee, meaning they can't terminate the employee because of the filing or the complaint, or they cannot reduce the employee's compensation or benefits or terms and conditions of employment because of the filing or the complaint. These are called protected activities.
Is the employee required to keep overtime records?
While the keeping of records is a good idea and is recommended, the employee is not required by law to keep records, though it's always a good idea to keep records. The law, however, requires the employer, as opposed to the employee, to keep records of the hours worked by the employee and of the wages paid to the employee by the employer. And the reason for this is so that if the employer is audited or if there's a lawsuit, it would be easy to prove that there was a wage violation or that the employer complied with the wage laws.
If a worker is illegal in this country, can a worker recover his or her overtime wages?
Generally, yes. While undocumented or illegal workers cannot legally work, if that person is hired by an employer and actually performs work for the employer, the courts are of the opinion that that person, even though they're illegal, he or she's illegal, could recover whatever overtime wages are owed. And the reason for this is simple. We don't want the policy behind it is simple, that we don't want employers hiring illegal workers to exploit them, and we also don't want employers to hire illegal workers, paying them an illegal wage, which might disadvantage legal workers who are entitled to the legal wage or who otherwise might demand a legal wage because they are legal and would demand their rights be respected.
How can you help workers who are not getting the right overtime wages?
Very simple. Our law firm, our main focus is in labor and employment law, and a significant part of the cases we handle are overtime and wage cases. Now, employees must understand that there are very strict deadlines when it comes to overtime claims. If you miss those deadlines, you will lose your claim. So it's very important. We offer free consultations. If you call us, you don't pay, we will consult with you for free. If you contact us, we'll consult with you for free. And if we decide to take your case, we will generally do so on a contingency basis, meaning we do not get paid unless we recover money for you. So if you believe that you work more than 40 hours a week and were not paid overtime, call us or contact us now for a free consultation.
Is there a deadline for bringing in overtime claims?
Yes, there is a deadline. As I said, the law imposes deadline. The federal law imposes a deadline. The state law imposes a deadline. So you call us. We will try to compute that deadline for you, and you have nothing to lose by calling us, but you have a lot to lose by not calling us.
All right then, Mr. Hassan. We thank you for taking your time to answer our questions.
You're welcome.